This case, heard by the King's Bench in 1919, established one of the fundamental rules of contract formation, that an agreement or bargain is only a contract if the parties themselves intend that their agreement should be enforceable by the courts. Mr Balfour, a British public servant, was posted to Ceylon, which we now call Sri Lanka, and which was then part of the British Empire. He was the Director of Irrigation. His wife went with him to Ceylon for about 10 years. In late 1915 they returned to England on leave, but Mrs Balfour was struck with rheumatoid arthritis. Doctors said she should remain in England for a few additional months. Mr Balfour didn't want her running up credit on his behalf, so he promised her a monthly allowance of £30 to support herself. She agreed to this arrangement and he returned to Ceylon. Sometime later he wrote to her saying that they should remain apart. They later divorced. She sued to continue the payment of £30 per month after their separation. The question was whether they had actually made a contract. They both had capacity, there was offer and acceptance, the bargain was sufficiently clear and certain. It wasn't clear whether she had actually given anything in return for his promise, but most of all, it was not clear that the parties had actually intended to create legal relations. It was not clear that they had ever intended this to be the sort of agreement which could be enforced by the courts. The presumption established by the court was that any agreements made between husband and wife were not intended to be contracts in the legal sense. Lord Atkins said, "The small courts of this country would have to be multiplied 100-fold if these arrangements were held to result in legal obligations. They are not sued upon because the parties never intended that they should be sued upon. Agreements such as these are outside the realm of contracts altogether. In respect of these promises, each house is a domain into which the King's writ does not seek to run, and to which his officers do not seek to be admitted." In the modern context, the rule is that agreements between close family members are presumed not to be contracts unless one party can prove they really did intend for the courts to enforce the agreement.